So, in this video, we will discuss question number 9 that already we have mentioned in the last video, and that is under what circumstances an accused under the Prevention of Food Adulteration Act given the benefit of doubt. Discuss citing decided cases. So, in the first leading case, that is Sarad Mal Jain versus Nagar Nigam. In 1996, the Apex Court held that the sample was taken on 30th September 1981, a period of preceding rains, and the report of the director came more than 4 months thereafter. The sample contained moisture, and the possibility could not be ruled out that when no preservative was added to the sample, the moisture content could have led to the appearance of larvae, cocoons, including insects, live and dead, depending on their appearance due to the natural factors. Therefore, the accused was extended the benefit of doubt, and in the second leading case of Ram versus State of Madhya Pradesh in 1996, the Madhya Pradesh High Court held that as the milk was brought for preparing tea for the guest, and the accused person had told the food inspector that it was not for sale. In these circumstances, the conviction and sentence is set aside, holding that the prosecution has failed to prove its case that the accused was a milk vendor and he had brought milk for sale and had actually sold it to the food inspector. And the last important leading case relating to this question is Ram Vishal versus State of UP in 1996. The Allahabad High Court held non-production of the postal receipt and postal acknowledgement clearly created a suspicion in the mind of the court whether the report of the public analyst was really sent to the accused. This benefit of doubt must go in favor of the accused only. So now we'll go to question number 10, and that is, do you think is there any scope for an accused to take defenses in prosecution under the Prevention of Food Adulteration Act 1954? Discuss, and the very answer to this question that we found under the provisions of Section 19 of Prevention of Food Adulteration Act 1954. So, Section 19 of the Prevention of Food Adulteration Act provides the scope of defenses which an accused may or may not get while prosecution is proceeding. It shall be no defense in a prosecution for an offense pertaining to the sale of any adulterated or misbranded article of food, alleged merely that the vendor was ignorant of the nature, substance, or quality of the food sold by him, or that the purchaser, having purchased any article for analysis, was not prejudiced by the sale. A vendor shall not be deemed to have committed an offense pertaining to the sale of any adulterated or misbranded article of food if he proves the following: that he purchased the article of food in a case where a license is prescribed for the sale thereof from a duly licensed manufacturer, distributor, or dealer. In any other case, from any manufacturer, distributor, or dealer with a written warranty in the prescribed form, and secondly, that the article of food while in his possession was properly stored and that he sold it in the same state as he purchased it. So, any person by whom a warranty is alleged to have been given shall be entitled to appear at the hearing and give evidence. So, this is the appropriate answer as per the very provisions of section 19 as provided under Prevention of Food Adulteration Act 1954 relating to this very question. Do you think is there any scope for an accused to take defenses in prosecution under the Prevention of Food Adulteration Act 1954? Discuss. And now we'll go to the last selected question that we have made, and that is: can an offense committed under this act shall be cognizable and non-bailable? And if so, state how. And regarding the very answer to this particular question, we have to go to the very provisions under section 16 subsection 1AA of the Prevention of Food Adulteration Act of 1954, also section 20 subsection 3. So what exactly the provisions relating to that we would like to discuss, which would be the very appropriate answer to question number 11. Notwithstanding anything contained in the Code of Criminal Procedure 1973, an offence punishable under subsection 1AA of section 16 of the Prevention of Food Adulteration Act 1954 shall be cognizable and non-bailable as per the provisions of section 20 subsection 3, provided that a prosecution for an offence under this act may be instituted by a purchaser or recognized consumer association as referred to in section 12 if he or it produce in court a copy of the report of the public analyst along with the complaint. No court inferior to that of a judicial magistrate of the first class shall try any offence under this act. So, any police officer not below the rank of a sub-inspector of police may arrest without warrant any person against whom a reasonable complaint has been made or credible information has been received of his having been concerned in any of the offences punishable under this act. So, all offences punishable under this act shall be cognizable and non-bailable. So, these are the important selected questions that we framed from the very Act, Prevention of Food Adulteration Act 1954, by considering those provisions of the Act which are most important and relevant in the examination context. So, all the examinees, those who are either appearing 3-year or 5-year LLB exams or any topic relating to business law or commercial law, they would found these questions and those relevant answers which those relevant leading cases would be sufficient for them. So it would be our request to kindly follow these questions and listen the very answers carefully and attentively to get into the very provisions and the very content of this act, the Prevention of Food Adulteration Act 1954.